Welcome to Real Estate Reality, where we talk all things real estate. I'm Dawn Satterjay, your host, and today I'm lucky to have with me Sandy Kelsey from Kelsey Law right here in Rocky Hill. Sandy, thank you so much for being here.
Good afternoon, Dawn. Thank you so much for having me here.
I have so many questions for you. But what I kind of want to start with is the fact that, so Sandy handles, obviously, real estate closings, a lot of other real estate related issues, and many, many other things. However, real estate is what we want to talk about. So in a sale and purchase agreement, we always have one contingency that has to do with the seller conveying clear title to the buyer. So can you give me a little bit of an idea as to what that means?
Absolutely. And so when a seller in the state of Connecticut conveys title to a buyer, they do have to convey clear and marketable title, okay? Which means that as a buyer, you're going to take that title in without anybody's mortgages on it, with no tax liens, nothing that's going to encumber or cloud the title, so that when you receive that title, it is clean.
Okay, so it means you own it.
Well, you own it. Yeah, you can still own it and still have some encumbrances there from the past. And that's why we always have a title search performed before we will accept title from a seller.
Is there a time frame that the title search goes back to? Like, does it just go 40 years or does it go 100 years?
Well, it's typically 40 years is what
Okay.
we're required to search in order to issue what's called a title insurance policy.
Okay.
Which is going to insure that title to make sure that when you are accepting that, it is free and clear.
Mm-hmm.
And if anything is to come up to try to encumber that title or something comes to light, then that title insurance policy would kick in and a team of attorneys will go in and quiet that title on your behalf and in whatever fashion they have to do that.
Okay, so what does that mean? So what could possibly come up besides somebody's mortgage, if a mortgage release isn't done or something, but what else could come up on that?
Oh, you would be surprised, Dawn. And I've been in this industry for over 20 years practicing, and you think that nothing's going to happen, and things happen, Dawn. They certainly do. So, I mean, it could be anything from a mechanic's lien to an unreleased mortgage. You could find that maybe things were transferred through probate and weren't released properly with probate lien releases, things of that nature. It could be easement issues. It could be boundary line issues. There are so many things that could come up on title that title insurance would
Let's talk a
cover.
little bit about that. So as you were saying that, I completely forgot. So once upon a time, and this was probably 20 years ago, I remember I was in the process of selling a house. It was my listing. And no one knew that part of the seller's driveway apparently was on the neighbor's land until the title search came up. And it was found, and the sellers had no idea. They had done a title search when they bought it. But apparently this was somewhere missed in the past. Mm-hmm. So how does that get, as you put it, quieted? Silenced.
So it kind of all depends. You can flush that through in a couple of different ways. I mean, it's highly unlikely that your neighbor is going to move their driveway. But certainly if you were issued a title insurance policy, you could go back to the title company and they would handle a claim for you. So you may have a diminished value in your property due to having that encroachment. There could just be many things. So it can really be handled many different ways.
Okay. So title insurance is extremely important.
Extremely important, it is.
So I have recently, in today's market, there's a lot of cash buyers out there. Mm-hmm. And a lot of times the cash buyers say, why do I want this? What do I need it for? Because if somebody's getting a mortgage, a buyer essentially is forced to buy it, at least for the bank's portion of it.
Right. So what you should know, there are differences. There
Mm-hmm.
are mortgage title policies which insure the lender, and there are owner policies that insure the owners of the property. So essentially, just to boil the whole thing down, it's kind of runs like this. Your lender policy is going to be a requirement. No lender, at least in the state of Connecticut, is going to give you a loan without having that policy, okay? Mm-hmm. What happens is when I get a contract into my office, if I am representing the buyer, I will either have the search performed or I'll perform it myself to make sure. We'll get a report back. We will review that, and then I report to the lender. And I say to the lender, okay, these are the things that are on title, but you, lender, are going to be number one in priority lien position when we close this, okay? It's part of my job to then deal with the seller side and make sure they're going to clear everything off the title. So they're going to have mortgage payoffs, they could have, lien releases and things that we're going to need. So that's my job, is to make sure that's all cleared off. We are then going to issue title policies, okay? We're going to accept that title over, it's going to be clear as far as we know, and we're going to issue a title policy. Things can go wrong, and you say, okay, well, you've done a title search, so there should be no issues. But what if I send someone out to do the search and they haven't had their coffee that morning and they missed something? What if the recorder's office has misindexed something and so it's not findable on the land records? Okay. What if there's just totally a mistake made on the land records? What if something was never recorded and then somebody still comes in to stake a claim? So all of those things would be covered in title insurance. But if you're only going to get the lender's policy because you're required to, then only the lender is covered. And the problem is you're still dangling out there. So where they're going to go, the attorney's going to go out and quiet the title on behalf of the lender, you have no coverage. And that could be quite expensive to send a team of attorneys out to quiet the title on your behalf unless you have the title insurance.
So what could the expenses be?
Well, you know what? Many of my clients are always concerned with the cost of title insurance. So this is what I can say about it. Title insurance is based on the purchase price of the property and the loan amount, okay? So I could go, there's many title insurance companies, a lot of wonderful places out there, and it doesn't matter which one I go to. Your premium is going to be the same no matter which title insurance company I choose to go to, okay? That's number one. Okay. The other thing about the premium is it's a one-time payment. It's not a monthly like your homeowner's insurance or anything. Mm-hmm. It is a one-time premium that you are going to pay at the time of closing. The owner's policy is going to last you forever and ever and ever. And I always tell my clients, get the owner's policy when you are purchasing. It is so important. You will never buy it again. If you refinance the property with another lender at some point in time, you will not need owner's coverage, okay? I also like to tell my buyers that when they get the policy, we'll get everything over to them, several weeks after closing, and nice letter and says, hey, keep this somewhere in a safe place. Don't get rid of it even if you sell the property, okay? Because you have to think about this insurance as going backwards in time. It does not go forward like your car insurance or your health insurance. This covers the past. So this covers back. If anybody knocks on your door, either during your period of ownership or later on after you've already sold the property and gone away, if somebody knocks on that door and they say, hey, I've got a claim to this property for any reason, that title insurance policy is still in force forever. Okay. And so you can go back and put the claim in with the title company and they will quiet that title. Now, what's the cost of that? It's minimal. It's really minimal. And like I said, it's all based upon the price of the property and the mortgage amount. So I did take the liberty of just doing a little bit so you can understand what cost might be. And I just picked like an average $300,000 home, okay?
Yep.
If you just got a home at $300,000, a lender's title insurance policy on that would be approximately $1,145.
And that's something you have to get. The lender's
That's
going
something
to
you're
force
going to get if you're getting
you have
a mortgage, okay?
Correct. Yep.
Owner's title insurance is going to cost you $103.
So that's minimal.
So for
to protect you.
$103 on a $300,000 home, why would you not?
Right.
And it is a one-time fee. You could go up to, you can go, if you're getting a $100,000 house, you're looking at about $22.
Wow.
One-time fee, $22. And if you're getting $1 million house, you're looking at an owner's policy at about $265. Now, there are certain other endorsements and things that you can add on if it's a condo or a PUD or, there's different, variables to it you could add on, but they're not expensive. And again, one-time fees. So why would you not want that assurance
It seems like
forward?
you would want to. Yeah, just to protect yourself,
Right.
protect your investment. So have you ever had anyone that had to use their title
I
insurance?
have in the past. I've had a few different instances with some boundary line issues, almost like
Okay,
you were
same thing.
describing. I really haven't had anybody come back that in 20 years that has had like crazy things on title, but it does happen.
Those are the stories we always hear, so.
You do hear some crazy things out there that you would never think. Thank
Yeah.
goodness it hasn't crossed my door, but I've heard them all over the place. So.
Yeah. So, okay, so that's all really good information. So in other words, get your title insurance, people. You're going to want it, just a little extra protection. So, but now I kind of want to go to today's market.
Right.
This crazy wild ride that we are all in today's real estate market. So the last show gave the perspective from an agent
Okay.
who does a lot of work and, you know, what needs to be done to make sure to try to get your buyer's offer accepted. Because, you know, I just had a listing the other day. We ended up with, it was 40 some odd offers on the property.
Oh, yes.
So you try, you know, with 40 offers out there, you try to make your offer stand out if your
Certainly.
buyers really, really want it. But now, today, getting a perspective from your side.
So I am seeing a lot of this, and I'm seeing a lot of offers that are being accepted with no inspection contingencies whatsoever. You know, that's great, and it may get your offer accepted because guess what? The seller doesn't have to worry about you coming in and nitpicking about, I don't know, a broken this or a broken that, and then they have to spend more money to fix it and are big negotiations. They just want to sell it to you, take it as is, and, you know, let me move on and do different things,
Let me pack
right?
my bags and move south.
Exactly. So that's fine and good. It may get your offer accepted, but this can be very dangerous.
Okay.
And I understand everybody wants to move and to do things, and you know, I get very nervous because I feel like I advise my clients to at least go in with a clause that says the inspection is for informational purposes only.
So that's a big one right now. So that, I am so glad you brought that up. You have no idea. So my take on an informational purposes only, so if it's my listing, the buyer comes in, they want to do a home inspection, that's great. Our inspections are for informational purposes only. Okay, for whose information? For the buyers?
That's for the buyer's information, and
Okay.
I recommend that they at least do that. If they're, you know, if you're a contractor or you are a home inspector, great. Maybe you can see some things as you're walking around. But if you don't have those areas of expertise on your belt, you need to at least be able to look, have a licensed home inspector come in and see what they can see. Is there a cracking foundation? Is there a problem with the roof? You know, look, maybe some of the small things don't matter, and you're willing in this market that, you know, we'll fix this or we'll fix that.
Right.
But when it comes down to crumbling foundations, when it comes down to structural issues, that's real important.
Yeah.
And,
So,
you know, at least this way, the buyer has the option to know what's wrong, and you may not then be able to ask the seller to fix anything because it's an as-is sale.
right.
But at least you're not going to spend your money and then have to pay more money for large corrections to the property.
So your interpretation of that would then be, so informational purposes only, however, the buyer is still reserving the right to terminate if something,
They can be reserving the right to terminate
Okay.
and get their deposit back, and some of them are saying, we will not take the deposit back. It's a non-refundable
Non-refundable.
deposit,
It's a
but
new
we
one.
do reserve the right to terminate the contract.
yep, okay.
So, you know, a couple ways you can go with it, but I think you at least deserve the information to know what you're looking at when you're buying your home.
Well, some of these
or
are
investment
large.
property.
Yeah, I mean, in
Right.
certain areas of the state, we've been pretty lucky in this area that
Mm-hmm.
we haven't been dealing with the crumbling foundation issue.
Well, you'd
So-
be surprised, Dawn. And
Oh.
I will tell you, I had one last year it was actually still in a time of multiple offer situations and craziness. And I had clients had been looking for 2 or 3 years, and they finally found a property over in Glastonbury.
Yep,
And they put an offer in. This was $700,000 home, beautiful home. They waived all inspections, which is not my advice. And later on, through various channels, found out that this was a crumbling foundation.
ooh,
And thank goodness it was brought to light before the closing took place.
okay, good.
The closing took a lot longer to happen, but we were able to put in place a plan for corrections and get estimates and do all those things so that when the buyer did purchase this house, they were well aware of what the obligation and the liabilities were going to be, as the seller was too. And so we're able to close, but that could have been a situation where they had, a $60,000 deposit down and could have possibly stood to lose that deposit.
That would have been huge. So banks are still lending then on the properties, even though they're flagged, or did the property not get flagged with this crumbling
This
foundation?
property did not get flagged because
Okay.
we were already within, we got them into the crumbling foundation program with the state, and, it'll be
Gotcha.
taken care of and so on and so forth. So that one did not get flagged, so we didn't have to deal with the lending on that.
Okay.
But, and that will lead me to, some people saying, well, we're just going to rely on the seller's disclosure. The seller is obligated to make certain disclosures under Connecticut general statutes. They have to disclose certain things, okay? It's up to the seller's knowledge of what is there, but how do you prove they had knowledge of, maybe a crumbling foundation you could, but how do you prove that they had knowledge of anything else? That's where it gets a little sticky in litigation. So
It could.
disclosures are great, but I would not rely upon them 100% and waive
Yeah,
inspections.
and I do think the disclosures say that. This is just to the best of the seller's knowledge. However, it is recommended that buyers have a home inspection.
Right.
So, yeah, I do feel for buyers in this market because it's such a tough market. And, but sellers, at the same time, why not? If you can remove one more contingency, why not remove one more contingency?
Right.
So that does make sense. How about permits? That's
Oh.
another, Pandora's box almost.
Yeah, permits. So it is very important to make sure too that, and we used to do what they call municipal searches to
I'm
look
seeing
for
that come
open permits. We used to just do them on commercial properties, but with everybody building and doing different things on their house, we are tending now to do more municipal searches on single-family residential as well, and it is important. There is a law in the state of Connecticut that says if a permit was pulled by a homeowner and 9 years has elapsed and the permit hasn't been pulled, then you are okay. But if a permit was never pulled and they found out work was done, you have a problem. And it's upon that owner then to then go and pull the necessary permits. And that could mean ripping out walls to show electrical, plumbing, things of that nature. And it can be very expensive.
Oh, yeah.
I will tell you that, I'm glad you said that, because part of an owner's title insurance policy, an expanded policy, which isn't much more than the standard policy, can cover some of those permit issues as well.
Okay, so that would be if somebody finished their basement in 1999.
Never pulled a
Never pulled a
permit,
permit.
and so that could cover. So it does depend on the scenario, case by case,
Okay,
but those expanded policies can cover some of those things.
okay. That's interesting to know as well.
But a lot of people, what I'll say this is too, it's very difficult too because, as the lawyer, I don't visit the properties typically, although
Right.
we'd love to. We can't get to all these properties. I don't always know what work has been done. So I can have one of my title companies go out and do a municipal search, and we get it back, and we can see that, there was a roof permit pulled, and it was closed, so it was all done appropriately, it was all good. But I don't know if there's been work done that no permit was pulled.
Right.
I would have no way to know that. So if you see, a brand new roof, or you see something as a buyer going in and you go, oh, well, that's new, you want to alert your counsel so that they are looking specifically for those permits. There's a swimming pool, you got to tell me there's a swimming pool so that I know to look for the pool permit,
Right.
right?
So do you automatically do municipal searches as well, or does that need to be requested
We
by?
don't. We will typically send our engagement letter, and we'll explain to our clients on the onset that we
Okay.
don't typically do a municipal, unless we're doing a commercial transaction or multifamily, sometimes we will definitely do. All depends on the scenario. But typically on single family, we won't. We will leave that up to the purchasers, and we'll explain to them why we think they're needed. Municipal searches can run you anywhere from, I don't know, $125 to $200. It just kind of depends. It could be well worth it, especially if you know that you are buying from somebody who has already flipped the property.
Yeah, you want to make
things
sure
of
those
that
permits
nature.
are done, simply because, well, you want to make sure they're done right.
Well, it's not just
Insurance.
Well, right, but it's the safety. It's the safety of your family too, because when you move in, you want to make sure everything is to fire codes. You
That's
want to make
true.
sure everything is safe, and your family is going to be protected.
So speaking of family, so this has come up a couple of times recently as well. So a lot of people, unmarried couples, are looking to buy a home together.
Yeah.
So what is your advice to them with that? So it's, because it doesn't fall under the same, like a married couple is essentially, right? There's one type of
So-
claim if there's a divorce later.
Right, there's a couple things that I always look at. First and foremost, make sure the lender is on the bus as far as who's going on title, because I've so many times that even I have married couples come in. I had a married couple today who was purchasing a home.
Yep.
And it was a conventional mortgage, and the man said, well, I'd like my wife on title. And I said, well, now that's going to be a little difficult, because typically part of a conventional mortgage says that if you transfer beneficial interest in your property, you could be in default. You know, had they alerted their lender early on that wife wanted to be on title, she probably
Yep.
could have been put on title without being on the note, okay, without being on the promise to pay, but is on the mortgage on the title. So, you know, we can explain all those things. But unmarried couples getting a home together, you really have to know that you're both on title. You need to kind of figure out how you want to hold that title. And there are different ways in Connecticut to hold title. Two of the main ways are you're going to be joint tenants with the right of survivorship. That means if one of the parties were to pass and go to the great beyond, then the other one owns the whole property outright. And another way to own is what's called tenants in common. And what that means is that you and I own the property, but if I go to the great beyond, my heirs and beneficiaries are going to inherit my piece, and then you still own your piece. All right, so there's different ways to own. So they have to, you know, an unmarried couple should be explained those situations and how do they want to hold title. And you may talk about a little estate planning too. At
the same time,
At the same
yeah.
time, because, you know, different rights are there, so.
Okay, so there's a lot going on. A lot of this stuff going on behind the scenes. You don't even get credit for it.
No.
People don't even realize you're working on it until
You make
the day
it look
they
so
show up.
easy.
Yeah, they show up for closing and they're saying, oh. So what else did I want to ask you about? Oh, I did want to ask you about probate issues. So to get a home ready to sell, so in Connecticut, somebody passes away, say, you know, mom dies, leaves her house to her 3 kids,
Okay.
right? So the kids can't just turn around and sell the house and split the proceeds, correct?
No, the house, if the house is entitled in mom's name and she leaves it to her children, you still have to go through the probate process. And I want to make very clear too, I've come across a lot of properties of late where you have a husband and wife owning in joint survivorship. So it means if one party passes, the other party owns that property outright, okay? You still have to go through the probate process, even though that title nice and quietly passes over to the remaining party. You still need to go through probate. Why? Everybody says, why? Why do I have to do that? That's why we own it this way. Well, part of the reason is because there are probate fees that may be due, and certainly, you know, the probate departments need to collect those funds, and also succession taxes, what I like to call the death tax. They get you coming and going. So, so essentially with the succession tax, there are limits, and most average Americans don't owe succession taxes these days. However, you still have to put in the form that shows what your gross assets are. And as long as it falls below a certain level, I think in Connecticut right now, the level is $7 million of total gross assets, and for the feds, it's $12 million. Like I said, many folks do not hit those levels, and they don't owe the succession tax, but it's the IRS and the government, so you have to put those forms in and get a release from the probate court to be filed upon the land records, and that will clear that title.
Okay, so that's an important thing, because I don't think a lot of people are aware of that.
They're not, because I have people coming in droves of late who have lost, unfortunately, a partner, husband, wife, whatever, and they think that they can just go and sell. And so we're scrambling now to do probate for people to make sure title is clear to convey to a buyer.
Okay, so that's important. So same thing, so then let's say, so then the survivor passes away, so now they have...
And leaves it to the kids, that's great, but depending on whether there's a will or there's no will, you're still going to go to probate, and basically the judge is going to hit the gavel on the desk and decree that it's okay for that sale, sometimes, depends on how the will reads. And if there's no will, the judge definitely needs to slap the gavel on that and approve everything. And then it can be passed to the children or the beneficiaries, the heirs, whoever it is,
then
But
they
we will
sell it.
also make sure that there is no succession tax due, or if there is, it's paid, and that all the probate fees are paid. And we will still get that same release for the land record so that you can provide clear and marketable title.
So how often are you scrambling to get that release?
Very often of late, very often. And there's different levels of probate in the state of Connecticut. There are, you can do what's called a TPO, or tax purposes only probate sometimes, if that was the only asset. There's many different things that you can do.
So people should come
Well,
talk with you first.
they need to get some counsel before they list the property if they are taking this through a deceased individual. So they should get some advice on what's the best way to go. You don't want to end up where you have a contract, everybody's ready to close, and you find out 2 weeks before
can't.
that you need something from probate.
Right. Absolutely. We've all been there, though.
Yeah.
So let's see, what else did I have to ask you about? I was going to do probate. Oh, the fun one, the divorces.
Oh, well,
So divorce mainly. So here's one of my most important questions is, let's say we have a couple who they're getting divorced. One wants to stay in the house and the other one's in agreement. So the divorce is kind of in process, but I believe at the beginning of the divorce, they both sign off that they're not going to spend any of the assets until it's decided, right? So one says, I'm going to go buy a house. So I have a place to live. You can stay here. I need a place to live. And the other one says, fine, you can go buy a house. What happens then? Does this new house then belong to both parties?
Well,
There's quite a bit.
technically, I guess it's a marital asset. I would definitely refer to family law attorneys on that. But what I will say, what I see in the real estate world is, and I always counsel my clients, you can quitclaim your property to anybody, to your spouse. If you know you're getting a divorce and you say, okay, I'll give you a quitclaim deed, that does not take you off the mortgage. Right. So I am very clear with clients that come in and say, hey, I need to do a quitclaim deed. I'm getting divorced and I need to give my property to my soon-to-be ex. Can we just draft that quitclaim deed and get this thing done? And I say, absolutely not. Are you on the mortgage? Because that doesn't make your obligation go away. And part of that problem is you transfer the house, you've now lost your standing or your right to say what goes on with that house, but you still have this mortgage obligation. And you will probably, for most of us, you won't qualify for another mortgage if you have an obligation out there. They talk about your debt to income ratio when you're dealing with mortgage lenders, and your debt to income ratio is going to be way off, and you may not be able to support 2 mortgages. So it's really got to be done properly through the right family law attorneys and channels. We certainly can assist with preparing the quitclaim deeds. One of the only ways, the main way to get yourself off of a mortgage is the other party would have to refinance that mortgage in their own name. And the bank wants to be sure that that individual can afford to do that and pay that mortgage. So there's a lot that goes into that as well.
Yeah, with today's rates, if they had a 3% rate and there were 2 of them on them, and now they're going to be
I am going to tell you, I had the exact scenario this morning. Clients of mine came in, they said, we're getting a divorce. It's actually a very amicable divorce, and they're all happy. But they went out and took a home equity line of credit to pay off the wife so she could go and do something else. Well, now you've got 2 mortgages we have to deal with. And so it's not just the one. And now we have to figure out how to maneuver all this. And they had, I think it was like a 2.5 rate.
Wow.
And now if they both go lock into different loans, you're probably going to be up near, 6% somewhere is the average.
Yeah, absolutely.
So, I may try to go to the banks and try to see if we can negotiate anything on modifications or, releasing the obligors in certain circumstances, but those are not guarantees.
Yeah.
Those are a little bit different, so.
Well, Sandy, we're getting the signal that it's time to wrap up. Thank you so much, and thank you so much for all of the information. So where can our viewers reach you?
Oh, absolutely. And Dawn, I want to say thank you so much for having me on. And it's great to be able to put some of these things out there, not just for, people buying and selling, but for some of the realtors too. So, if anybody has any questions, please feel free to give me a call. My office is 860-571-0189. We are located in Rocky Hill, but we pretty much cover the state of Connecticut. So happy to help.
A great resource. Thank you so
Thank you,
much.
Dawn. Great to see you.
You too.